In this bite-sized video, I explain gender reassignment discrimination, including the different types of gender reassignment discrimination prohibited by our equality law. Gender reassignment covers someone who proposes to go through, is going through, or has gone through a process to change his or her gender from man to woman or woman to man. A recent tribunal case, which is not binding, has held that gender reassignment also includes protection for gender fluid, non-binary individuals who have not gone through or are not proposing to go through a formal gender reassignment process. There are a number of gender identities for individuals who do not identify with the identity they were assigned at birth, cisgender. Identities include, for example, transsexual, trans, transgender, agender, non-binary, gender variant, genderqueer, cross-dresser. The charity Stonewall has produced a useful detailed glossary of relevant terms. It's unlawful for an employer to discriminate directly by treating a job applicant or employee less favourably because of their gender reassignment. An example of direct discrimination could be if you informed your employer that you wish to spend the rest of your life as a different gender, and as a result your employer took you off your role because they did not wish you to have client contact. It is unlawful for an employer to discriminate by applying a provision, criterion or practice that disadvantages transsexual people without justification. The individual has to be personally disadvantaged too. An example of indirect discrimination could be where the employer has a policy that employees' ID badges must always show their photograph when they join the employer. As the individual has changed their gender identity since, this could cause them considerable embarrassment. Harassment related to gender reassignment is prohibited. It happens where a person engages in unwanted conduct related to gender reassignment, which has the purpose or effect of violating someone's dignity, or creates an intimidating, hostile, degrading or humiliating environment for them. An example of harassment could be where colleagues refer to an individual as he or him when they are fully aware that the person has transitioned to live as a woman. Individuals must not be victimised because they have alleged discrimination, brought a discrimination claim, or given evidence or information in relation to proceedings. If a person raises a grievance at work alleging gender reassignment discrimination, and as a result is transferred department, this could be victimisation. Job applicants or employees who believe that they have suffered gender reassignment discrimination could bring a claim in the employment tribunal. Prior to issuing a claim, the job applicant or employee would need to follow the Advisory, Conciliation and Arbitration Services (ACAS's) early conciliation process. In some cases, it may also have been appropriate to have raised a grievance beforehand. Any claim must normally be filed within 3 months less a day from the act of discrimination, and that is subject to the early conciliation rules for extending time. For more information, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to my channel for updates.